Have you ever wondered what makes a contract legally binding? Why is it that when you agree to buy a car or sign a lease or accept a job offer, you are suddenly obligated to follow through? Well, it all boils down to a fundamental concept in contract law known as acceptance. Imagine someone extends an offer to you. This offer becomes a binding contract only when you accept it. This acceptance is what transforms a simple proposal or offer into a legally enforceable promise. In fact, under the Indian Contract Act of 1872, acceptance is defined as when the person to whom the proposal is made signifies his assent thereto. In simpler terms, when you agree to an offer, it becomes a promise. To illustrate, if person X offers to sell their horse to person Y for 1 lakh rupees, and person Y agrees to this, it forms a promise. But acceptance isn't as straightforward as just saying yes. There are certain essentials of a valid acceptance. Firstly, acceptance must be total and unqualified. This means that you can't change the terms of the offer when accepting it. If person Y decided to pay for the horse in installments, it would no longer be the same offer and would instead become a counter-offer. Secondly, the person accepting the offer, or the offeree, must intend to fulfill the promise. For instance, if person X agreed to sell a horse to person Y, even though person X didn't actually own a horse, it would be an invalid acceptance as person X had no intention of fulfilling the promise. Thirdly, acceptance must be communicated. It can't just be a mental agreement, it has to be expressed or implied to the person who made the offer. Fourthly, this communication must be done in a way that's indicated in the offer. If no specific way is indicated, it can be communicated in a standard and reasonable manner. Lastly, silence cannot be a mode of acceptance. The person making the offer can't assume that if the offeree doesn't respond, it means they've accepted the offer. In conclusion, a contract becomes legally binding through the process of offer and acceptance. But for this to happen, the acceptance must be valid. If it isn't, the contract becomes null and void, and neither party is obligated to follow its terms. This concept was famously demonstrated in the case of Carlyle v. Carbolic Smokeball Company in 1893, where the court ruled that an offer made to the general public could be accepted by anyone who fulfills the requirements of the offer. So the next time you find yourself accepting an offer, remember the importance of your acceptance in creating a binding contract. It's not just a simple yes, it's a promise that holds legal weight.